be able to come together and pass this bill. Second, we're going to be meeting on a contempt report recommended last night by the Select Committee to investigate the January 6th attack on the U.S. Capitol, and I will say more about that a little later. But at this point, I will yield to our ranking member for any comments he wishes to make.
Thank you very much, Mr. Chairman. Our hearing today, as you said, covers two items. The first I'll address is H.R. 5665, the Combating International Islamophobia Act. As the committee is aware, H.R. 5665 establishes an office to monitor and combat Islamophobia, thank you very much, within the Department of State. While I in no way condone any sort of bigotry, I think this proposed legislation is premature and perhaps ill-conceived. The legislation fails to define the term Islamophobia, meaning that the interpretation of the term will be left up to the Department of State itself. That's a recipe for a lack of focus and a failure on the part of Congress to provide appropriate guidance. During the markup on this measure, Democrats on the Foreign Affairs Committee rejected amendments offered by Republicans to ensure that the office would focus its efforts on the ongoing oppression and genocide committed against the Uyghur Muslim minority by the People's Republic of China, and rejected another amendment to ensure that the State of Israel's efforts to defend itself against terrorism would not be construed as Islamophobia by this proposed office. I think it's deeply unfortunate that the committee rejected these and other Republican amendments that would have ensured a more narrowly tailored and better defined mandate. After all, it's up to Congress to write clear, well-defined laws, and not doing so is a legislative failure. And I would urge the majority to rethink this legislation and provide more appropriate and narrowly tailored direction to the executive branch. The second measure before us this morning is yet another contempt of Congress resolution, once again arising out of the partisan Select Committee to investigate the events of January the 2nd. The subject of today's resolution is our former colleague and former White House Chief of Staff, Mark Meadows. As we will hear from our witnesses today, Mr. Meadows has cooperated in part with the Select Committee and has turned over a large number of documents in response to the Select Committee's request. However, he was also a high-ranking official at the White House, and as such is subject to ongoing claims of executive privilege which have been asserted by former President Trump. As this committee is well aware, President Trump has initiated litigation with the Select Committee concerning the scope of its subpoenas and covering questions of executive privilege. It's up to the courts to make a final determination of the scope of President Trump's privilege claims. The right to make that determination does not lie with Congress. In addition to former President Trump's lawsuit, Mr. Meadows himself has also initiated litigation asking the courts to consider these claims of executive privilege and to evaluate the subpoenas the Select Committee has issued to him. Given the fact that Mr. Meadows has initiated his own lawsuit over this matter, today's action is wildly premature. Both Mr. Meadows and former President Trump have a right to have the courts consider the claims of executive privilege, and the majority's determination that the House should instead refer Mr. Meadows for prosecution for criminal contempt rather than allowing these judicial proceedings to play out is astonishing. Criminal contempt is a punitive measure, one designed to punish a recalcitrant witness rather than to achieve compliance with the subpoena. And with today's activity, punitive is undoubtedly the right word. I find it very disturbing that the majority would seek to move ahead with a criminal contempt referral given these circumstances, and would strongly urge both the Rules Committee and the Select Committee to rethink this course. Threatening a witness with criminal prosecution when that witness has already sought judicial review of the subpoena directed against him is not only punitive, it's arbitrary and capricious. The Select Committee and the House should allow the legal process to play out. With that, Mr. Chairman, I yield back.
Thank you very much. I'm happy to welcome our first panel of witnesses today to provide testimony on H.R. 5665, the Combating International Islamophobia Act. Chairman Meeks and Ranking Member McCall, we are delighted that you are here. I now recognize the gentleman from New York, the Chairman of the Foreign Affairs Committee, Mr. Meeks.
Thank you, Chairman McGovern and Ranking Member Cole, of course, members of all of this August committee. I want to thank you for the opportunity to speak in support of H.R. 5665, the Combating International Islamophobia Act. I think we all know that anti-Muslim sentiment and violence is an issue, whether we're talking about here at home or overseas. And I think we all should agree that no person should have to confront discrimination because of their religion anywhere on this planet. And establishing an office at the State Department to help combat the scourge of Islamophobia is an important step to addressing the problem. The legislation, this piece of legislation, is closely modeled after similar legislation designed to combat another scourge, anti-Semitism, around the world. This important legislation is straightforward and should be uncontroversial. It establishes an office to monitor and combat Islamophobia at the State Department and grants authority to appoint a special envoy for monitoring and combating Islamophobia and requires the State Department to report on acts of Islamophobia in its annual human rights reports. Now, at our markup, unfortunately, the minority side of the committee could not endorse this absolutely straightforward and, in my mind, non-controversial legislation. Instead of addressing the matter at hand, we had some members hemmed and hawed about the FBI and critical race theory. But I try to run this committee where we open and hear all amendments, and serious amendments were given appropriate consideration in a bipartisan manner. Example, Representative Mass from Florida offered an amendment that required the advice and consent of the Senate for the Special Envoy on Islamophobia. This amendment will ensure that there are guardrails as to who can serve as the Special Envoy, and which addresses concerns that both parties had. It passed in a bipartisan way. Representative Green from Tennessee proposed adding Uyghur-specific language to the bill. Of course, last week, on the floor of the House, we passed Chairman McGovern's vital Uyghur Forced Labor Protection Act on the House floor, as well as the McCall-Meeks Uyghur resolution. And Mr. Green's amendment was a reasonable addition to Representative Omar's bill. And for the purposes of today's rule meeting, I have submitted a manager's amendment, which is a technical fix to Rep. Green's amendment by changing Xinjiang to the Uyghur Autonomous Region. But unfortunately, again, many of the amendments offered by the minority were not carefully considered proposals, and these were soundly rejected by double-digit margins during our roll call votes. Truthfully, though I like seeing all of you this morning, I wish I wasn't here. And I say this not because I don't like you guys and ladies and spending time with you on a December morning, but it's because this bill should be a suspension bill, actually. This bill should not be in the Rules Committee. The text of this legislation, if you review it, is pragmatic, it's practical, it's closely modeled off of the anti-Semitism special envoy legislation that passed the House last Congress 411-1 by a voice vote in 2004. So it seems to me we need to combat Islamophobia in similar manners. And we should do, and it should be a message that's coming from Congress, both Democrats and Republicans, united in this message that will go around the world. Let me close just by saying that examine the bill, look at it, compare it to the anti-Semitism bill. Not noise, not, generally we try on the Foreign Affairs Committee to a large degree to not play politics with the bills that are in our committee because it's too important, foreign policy, for all of us. So I'll stop there and thank you for your time and consideration. Yield back.
Thank you. Ranking Member McCall.
Thank you, Mr. Chairman. Let me first say I agree with my good friend, Chairman Meeks, that the fact we're before this committee means we failed to reach a bipartisan consensus, which we always try to do on our committee, and most of the time we do. I agree with the spirit and intent of this legislation, but I have several concerns. And first, though, let me say no one should ever be attacked or denied their human right or dignity because of their faith. And the United States government should be committed to opposing the acts of violence that we have seen directed at Muslims around the world. I've been a strong advocate for this. And like you, Mr. Chairman, I was horrified by the 2016 shooting in a Swiss Islamic center and the 2017 attack during evening prayers at the Quebec mosque. I also joined the entire world in mourning the 51 people who were killed in the Christchurch attacks in 2019. Republican members of our committee worked to condemn and punish the Burmese military genocide against Rohingya Muslims that began in 2016. And we're working to oppose the Chinese Communist Party's ongoing genocide against the Uyghur Muslims and other religious minorities in China. Today, somewhere between 1 and 3 million Muslims in China are being held in camps and being exploited for slave labor. Families have been torn apart as children are ripped from their mother's arms. Women are suffering systematic sexual violence, forced sterilization, and forced abortions. Parents are prohibited from teaching their Islamic faith to their children. In response, Chairman Meeks and I worked closely to craft bipartisan legislation that identify these gross human rights violations as a genocide. And I'm proud that legislation passed the House with bipartisan support. It was a critical step to holding the CCP accountable for their genocide against the Muslims. Serious bipartisan attempts to combat religious persecution like that are preferable rather than the rushed partisan effort before us today. The bill before us today, H.R. 5665, is a deliberately partisan bill. Committee Democrats made no effort to work toward a mutually agreeable approach prior to markup. The bill has no Republican co-sponsors. It garnered no Republican support during the markup. Legislation also prioritizes the religious persecution of Muslims over the persecution of other religions. There is no special envoy for the brutal persecution faced by hundreds of millions of Christians every day around the world. There's not a legislative special envoy specific to the rights of Buddhists, Hindus, Yazidis, or many other religious groups. In fact, since the bipartisan FY17 State Authorities Act, the general push has been away from special envoys, which have often been ineffective and even counterproductive. No case has made that this legislation will actually help. The committee has held no hearings on this issue. It's not heard from the administration officials or outside experts on how best to combat religious persecution of Muslims, very different from the special envoy for anti-Semitism. In fact, what I find most interesting, the State Department's Bureau of Democracy, Human Rights and Labor, the Office of International Religious Freedom, and the U.S. Commission on International Religious Freedom are already working to identify and combat such persecution, and they also report. Even more troubling, as the ranking member pointed out, the term Islamophobia is not defined in this bill. So how is a special envoy expected to combat Islamophobia if there's no consensus on what exactly they are combating? Republican attempts to correct this glaring omission were rebuked by committee Democrats. And on top of all that, the United States State Department has requested multiple substantive changes in this legislation before the House passed the bill. One of their requested changes is not to mandate the creation of the special envoy. This indicates they have very fundamental concerns even establishing this office. And in many respects, this State Department believes that such an attempt would be duplicative to what already exists at the State Department. Yet once again, the majority ignored requests by the State Department and the minority to address even these redundancies and ambiguities. So why, Mr. Chairman, are we here today? I think it's pretty clear. It's hard to conclude that we're here today to conduct a serious exercise to address religious persecution of Muslims. And I'd be happy to do that. Rather, it's clear it's a rushed, partisan messaging bill meant to portray Republicans as indifferent to the persecution of Muslims around the world. Nothing could be further from the truth. My good friend and the former chairman of this committee, Elliot Engel, would always say that when it comes to foreign affairs, politics should stop at the water's edge. And he was right, and he still is. And I'd hope in the future that we could approach important foreign policy concerns not in a rushed one-day process without any deliberation, without taking into account what the State Department has or their concerns, and that we can address these concerns as Americans rather than in a partisan exercise. And with that, Mr. Chairman, I yield back.
Thank you very much. I appreciate you both being here. Look, I fail to see anything partisan about the underlying bill here. For the life of me, I can't figure it out. I get it. There are some people in this Congress who supported anti-Muslim bans, who have said things that clearly are Islamophobic, and there's been a reluctance by some to call them out. But, I mean, the idea that this is partisan or controversial is beyond me. You know, we see Islamophobia all over the world. And here in the United States, we've talked about the Uyghurs. We're hopefully getting to an agreement today on a bill that will, you know, the Uyghur Forced Labor Prevention Act that we'll be able to adopt before we, you know, a compromise between the House and Senate that we'll be able to adopt before we leave here this week. But you know, but unfortunately, in this place, everything seems to be political. We all agreed on the Office on Anti-Semitism and a special envoy, and yet we have Republicans in the Senate that are blocking even holding a hearing on the nominee that the administration has put forward. I don't get it. You know, and I think that the more attention that can be brought on discrimination against people based on their faith, based on what they believe in, the more we can call attention to some of the outrageous things that are happening around the world, the more that we can coordinate with other countries to try to figure out a better way to combat it. I mean, it's about creating a better world. So I don't get it. And I agree with Chairman Meeks. This should be a suspension. And I reread the bill last night. I don't know why this is something that everybody in this chamber can't agree on. But in any event, it is what it is, and here we are, and we will bring this to the floor, and I yield to Mr. Cole.
Thank you very much, Mr. Chairman. I'm not sure it's a partisan issue at all. I think it's a question of whether or not the legislation's ready to go. Just out of curiosity, Mr. Chairman, and it is a pleasure to have you here. I'm sorry you're here on a December morning, but it's always good to have you and the ranking member here because you do both collaborate so well and have brought a lot of good legislation to fruition. And I always enjoy reading your joint press releases because I feel like the country and the Congress is speaking with one voice when I see you guys. And I think you do more of that than any other committee. So I say that with a great deal of respect and certainly enjoyed working with you. And the ranking member and my friend, the chairman here, when we got rid of some AUMFs that needed to get rid of, and we appreciate all your committee's done on that. So, but has the administration, back to the legislation front, did the administration request this legislation? Is there, and I don't know. I'm just curious if this is something that the administration's advanced, that this would help us?
No, I don't think that the administration requested it. They have no objection to it. I think this is really an expression I think that it's important for us as members of Congress to make, so that the world, just as, you know, in the same manner, we were on the floor just the day before talking about the Uyghur situation and making sure that our voices are heard. And so I think this is a way that the members of the House of Representatives, and hopefully the Senate also, say that we want to prevent Islamophobia, or we want to call it out wherever we see it, and make sure that it is part of a report that the State Department can do when they see acts of Islamophobia. So it's just a statement that the world needs to hear from us, need to hear our voices.
Well, I have no problem with us making statements. I always have concern when we create offices, you know, without due consultation with the administration. But as you say, as far as I know, they have no objection. Let me ask you, is Islamophobia defined in there in any way, shape, or form? Go right ahead. Take your time.
Go ahead.
Yeah, is Islamic phobia defined in the legislation, or what constitutes harassment or those sorts of things, or is it just something that, you know, sort of like pornography, you know when you see it?
No, I think that it's something like the anti-Semitism bill that we've passed almost unanimously, where anti-Semitism wasn't defined in the way that I think that you're describing. And so this bill and the language therein is very similar therein. Thought from the author is that, you know, they both are you know, scourges that we have to get rid of. So it is very similar to the anti-Semitism bill in that it wasn't specifically defined in the manner that the gentleman is talking about.
Okay. What about, again, terms like harassment, incitement of violence? Are those things defined?
Well, I think that it is defined in the sense that in statutes all across this country, harassment is defined. And so it is something that is easily determined on its face in that regard.
Okay, thank you. Let me turn to the ranking member, if I may. I know you're, like the chairman, both of you are serious legislators, and, you know, again, I'm not raising concerns simply to oppose the bill. These are just legitimate questions I have. Ranking Member McCall, do you have concerns over the lack of definition that I just brought up? I suspect you do from your statement. And should this bill be considered the same as the anti-Semitism envoy legislation that's been referenced by the chairman?
Yeah, thank you, Ranking Member. I agree. The lack of definition here and clarity should be done by Congress, not by the State Department. And that is what is lacking here. And I think it can be subject to misinterpretation, as was brought out at the markup. What if counterterrorism efforts from Israel, would that be considered anti-Muslim, for instance? This is a very tricky subject, and my view is if we're going to do this, let's do it right. And to your question about the anti-Semitism bills, both in 2004 and 20, that came after dedicated oversight hearings, was based on 16 years of experience with the anti-Semitism office before the special envoy was added. In contrast, today's bills are a result of a hurried, push prompted by, I believe, by the politics of the day. We haven't had any hearings on this. We haven't consulted with the State Department. Whether, what their points of view are. And the input we did get from the State Department was that they have concerns about this bill. They have concerns about the fact that the way the language is worded, they think it's duplicative because there are offices in place right now today that do this work and report on anti-Muslim behavior. So it just seems to me, instead of doing a rush process, if we're going to do this, we ought to be doing this the right way. And that's when you're a serious legislature, you have the hearings, you get input from the administration, and you go through a serious bipartisan process. And that was completely lacking with this legislation that's before this committee today.
Thank you very much. Thank you, Mr. Chairman. I yield back.
Thank you, Mr. Torres.
Mr. Chairman, I just want to highlight for my colleagues that on November 19th, the Taliban arrested 21 Ahmadis and initiated hundreds more. Minors were among those arrested. Ahmadi women and children were being stripped from their families. Truly an alarming situation that brought several of my colleagues together on a bipartisan way to try to address it with Qatar. So this is not the first incident that this group has had. This year, I think that we've addressed about 3 separate incidents. This is a community, the Ahmadiyya Muslim community is constantly under attack. And I'm very proud that you have brought this bill forward, Chairman, because I see it as a step, a first step to begin to truly focus, not just through the Ahmadiyya caucus, but really to focus on an issue, a growing issue that impacts so many of the families that I represent. So with that, I will yield back.
Thank you. Mr. Reschenthaler.
Thank you, Mr. Chairman. I appreciate it. It's nice to see my former ranking member, Mr. McCall, here today. Mr. McCall, I do have some questions. From my understanding, the bill does not condemn persecution or gross violations of internationally recognized human rights against Muslims. And Democrats voted down an amendment that would have appropriately focused the new office's efforts on the plight of the Uyghurs. Is that the case, Mr. Chairman? The ranking member McCall?
That is correct.
Could you expand on some amendments that Republicans try to put forward in committee that actually would have focused on the plight of the Uyghurs?
Yeah, there were several amendments to attempt to define or ask for clarification as to what Islamophobia is. We don't have a definition. We don't have a legal definition of that. It can be subjected to many interpretations. Certainly, Ms. Torres, what she was explaining, I've been a staunch advocate of the Afghan Muslims who are being persecuted right now by the Taliban. I worked very hard along Chairman Meeks to get them out of country to save their lives. And it's, to me, the women left behind is the most tragic thing about the entire debacle, the evacuation of Afghanistan. I think, but some of the amendments got into Israel's right to self-defense. That should not be included in this definition, that counterterrorism efforts may be somehow labeled as anti-Muslim. There are some amendments on Sunni versus Shia, Muslim on Muslim violence. This is immigration. This is very different from the anti-Semitism, which, by the way, again, many years were put into that with a lot of thought and hearings before we developed the special envoy. The State Department did not ask for this special envoy. I'm not sure they even want this special envoy. In fact, they want to go away from that. And I want to make this point for the committee. It's very, very important that monitoring and reporting are already carried out by human rights officers at our embassies around the world, as well as the state's Bureau of Democracy, Human Rights and Labor, its Office of International Religious Freedom, and the United States Commission on International Religious Freedom. The current nominee to serve as a special envoy for international religious freedom is Rashad Hussain, is a prominent Muslim American. The annual country reports on human rights practices include detailed country-specific narratives of human rights violations targeting Muslims. This annual report on international freedom Religious Freedom describes in detail the country-specific challenges and abuses faced by Muslims because of their faith, as well as U.S. government policy to address the challenges. So creating this new envoy in office would really duplicate these pre-existing efforts and further fragment the human rights advocacy conducted by U.S. diplomats. This is what we're hearing from the State Department. We're not hearing an outcry or a need for the special envoy. And before we pass a bill like this on the floor, it seems to me we ought to hear from witnesses from the State Department about this, but we did not have that in this case. And we all know that the best legislation is after you conduct the hearings, you get the facts, you get all the information in front of you, and then you craft the best legislation that you can. And that process was completely ignored in this bill.
Thank you, Ranking Member McCall. With that, I yield back. Thanks, Mr. Chairman.
Let me just say to the gentleman, with regard to the Uyghurs, that, we passed a bill on the House floor last week, and we've been working with Senator Rubio's office, and I think we will have an agreement where we will actually pass something that has some teeth in it, that will allow the Uyghur Forced Labor Prevention Act to become law, and basically deal with the issue of slave labor that the Chinese government is guilty of, and for the first time send a really, really strong and meaningful signal that when it comes to human rights abuses against the Uyghurs and against and when it comes to genocide, that we're about more than words. We're about action, and so hopefully that'll be resolved today. But I thank the gentleman for raising the issue, Mr. Perlmutter.
Thanks, Mr. Chair. Just a couple questions. Mr. McCall, isn't it true that at least a couple Republican amendments were added to this bill?
Yes, that is accurate.
And, I mean, I guess what I don't understand, just this is me, why there would be any opposition to condemning Islamophobia by the Republican Party. It just defies me. And what I worry about is that we've gotten into a time where the Republican Party, the Republicans in this building, not just being the minority, but are in opposition to everything, even condemnation of something like this, Islamophobia. And let's talk about the elephant in the room, Mr. Chairman. I mean, a lot of this arose because of a bigoted joke that a Colorado colleague of mine made that was caught on tape. And that joke was Islamophobic from the get-go. And so whether it's in Africa or Southeast Asia or Europe or the halls of Congress, we've got to stop this. And I think modeling this after the anti-Semitism bill that was passed earlier this year by, what did you say, Mr. Chairman, 411 to 1 or something like that? I don't know why we got to go recreate the wheel, Mr. McCall, why there had to be a whole bunch of hearings on this. Seems pretty simple to me. I yield back.
The ranking member get a chance to answer?
I made a statement to him, but sure, you can, if you want to answer, why do we got to recreate the wheel? Let's hear the answer.
I misunderstood.
No, I'm happy to have him answer.
My answer?
Mr. McCall, do you want to say anything?
Yeah, I think the State Department's concern is that you are recreating the wheel, that the wheel is already in place in the State Department, as I pointed out, and the reports are being issued on anti-Muslim persecution. This term Islamophobia is not currently in statute. It can be subject to different interpretations. I personally condemn the remarks made by the Congresswoman, and I know she apologized for that. And I know there was an attempt to take her off her committees. And I think this was put in place as a substitute at the 11th hour, at the last minute, in a committee markup that I didn't even see coming, because we hadn't had one discussion about it or one hearing about it. We hadn't talked to the State Department about it. And when I did talk to the State Department, they said, we already have that wheel. you're duplicating efforts here. It seems to me we ought to listen to them because they're the ones that have to implement this law as to what is most effective. But we never had that opportunity. And Mr. Palmer, I have a lot of respect for you, and you know that. And I just think there's a right way to do this and a wrong way. I don't disagree with the intent behind this. Mr. Meeks and I are very strong against any persecution based on race or religion. And certainly our efforts, the chairman and I, our efforts on the Uyghur Muslim genocide and the forced slave labor protection bill, I think bears that out. I just think the process was violated.
Okay, I yield back. Thank you.
Ms. Fishbach?
Thank you, Mr. Chair. And first of all, I just want to say you are healing up so well.
Thank you.
You look good.
Yeah.
So,
Makeup.
okay. Well, you know, makeup does a lot. Makeup can do a lot of stuff, so I'm glad you're using it. But in all seriousness, just wanted to, I know that Ranking Member McCall mentioned, I guess when you were responding to Congressman Reschenthaler, that you're not sure that that the State Department wants this. Is that, did I hear that correctly?
I'm sorry, correct. We know the State Department has told us this is duplicative, that they are moving away from these special envoys. They question the effectiveness. They wanted this to be permissive language, not mandatory. Just some examples. But they also wanted to weigh in a process that we hadn't heard from them in any hearing or testimony. And it just seems to me if we're going to do something of this importance, and it is important work, that we need to hear from our State Department and address their concerns, and they have many regarding this legislation. And this is the State Department that we're talking about.
So, Ranking Member, none of the changes that you think that the department has requested are in this bill, or are there any that were incorporated?
No, none of the concerns I've seen addressed by this State Department have been addressed in this bill.
Thank you. And you know, I do share my colleagues' concerns regarding the fact that there's not a tight definition and that this definition is going to be left up to the State Department. Did anyone ask, and maybe this is to both the Ranking Member and the Chair, did anyone ask the State Department about their feeling on, you know, defining it and how they would, or any information on that?
The State Department affirmed of the issue of Islamophobia and that we needed to act and we need to do something in regards to Islamophobia. I think that, and I agree with the Ranking Member, you know, when he talked about what was taking place with the Uyghurs, and he saw that there was persecution taking place. I don't think that we need to go above and beyond. He saw it, and he knew what he saw. When we see it, we know it, and we should call it out. There's been no question why we got to say, well, wait a minute, let me think about it. Was this persecution or not?
Between persecution and phobia.
And when we see it, we should call it out. And I don't think that we should be put in a position where we only call it out when it's somebody that is our adversary. Because whether it's our adversary or our ally, if we see that people are called out because of their religion, we need to call it out. And for me, just looking at the bill, what does it do? I don't know why it's controversial. Basic. It establishes an office to monitor and combat Islamophobia. That's what it does. What's wrong with that? It grants authority to appoint a special envoy for monitoring and combating Islamophobia. What's wrong with that? And requires the State Department to report on acts of Islamophobia and its annual human rights reports. That shouldn't be something that's just specific to China. When we know it, we see it, we call it out. And we've had hearings in our committee about the Uyghurs and the Rohingyas and the Ahmadiyas. We need to call it out. I just say this, it's kind of personal for me in that I know I want wrong. We can't be silent. And the State Department having a division to combat it is America leading the world. And that's all this is done. And that's why I wish this was done on the floor.
Well, and Mr. Chair, what I was asking is about the State Department defining the terms. And maybe Ranking Member McCall would want to comment on that, because that was what my question was about, was the definition of those and what the State
The
Department.
State Department shares our definition and what the bill is, of what the bill is.
All right, maybe a Ranking Member would.
If I could, Greg and I are both attorneys, and of course, he went to Harvard. He's, we can debate that. He's probably a little bit smarter. But I would say, in my judgment, when you look at statutory language that exists today, it's always in terms of anti-Muslim persecution or terminology like gross violations of internationally recognized human rights, targeting Muslims. It doesn't get into phobias. And this is, I think, the biggest, I know this is a bit in the weeds, but it's very important, because what is a phobia? We don't know. What is a phobia is a fear. So it'd be a fear of Muslims that can be somehow, prosecuted over a fear. It's just, a lot of it has to do with statutory terminology. And quite honestly, as the Ranking Member said, it is the role of Congress to define, to make these definitions clear and the statutory intent clear, not to leave it up to the State Department and the administration. And I think that's one of the biggest weaknesses of this bill.
Thank you. And I will continue to just say I have concerns that we are not defining that, because when we put things into law, we need to make sure that we're doing it properly and that we have the bases covered. And with that, Mr. Chair, I'll yield back.
Thank you. Mr. Raskin.
Thank you, Mr. Chairman. I just want to say that this resolution, which I strongly support, is completely consistent with the founding principles of our country. America was created as a haven of refuge for people fleeing from religious oppression from all over the world. And our Constitution was written in such a way as to separate the church and the state, because the framers in the Enlightenment period had quite enough close-up and personal experience with the wars of religion between the Catholics and Protestants in Europe, the Holy Crusades, the Inquisition, witchcraft trials, all of it. And they wanted to create a government that would be a model for the rest of the world in terms of respecting everybody's free exercise of religion and not imposing any religion on anyone in any way. So the UN Human Rights Council found in March that discrimination and hatred towards Muslims around the world had risen to epidemic proportions. We know about the Uyghurs in China. We know about Muslims facing persecution in a lot of different countries, including in Muslim countries. As my colleague points out, the situation of the Ahmadi Muslims in Pakistan is a nightmare, and we need to defend their rights against persecution. The American position is to defend minority religionists and freethinkers of all different stripes against governmental persecution and social ostracism and hatred. So I think that this legislation is perfectly consistent with that, because it's saying let's identify, as in the case of anti-Semitism, a real problem in the world, and let's use American influence and persuasion to try to protect people who are under the gun just because of what they believe. So I thank you for bringing it before us, Mr. Chairman, and I yield back to you.
Thank you. Ms. Scanlon.
Thank you, Mr. Chairman. I do support this
this legislation. We know that international violence against Muslims is at an all-time high. Your committee has held multiple hearings on this topic. China's holding the Uyghurs in concentration camps. Burma's committing genocide against the Rohingya. India's politically oppressing Indian Muslims. These developments mirror a worrying increase in extremism, ethnic violence, nationalism, and authoritarianism worldwide. These developments also mirror disturbing trends here in the U.S., in communities across our country, and in the actions of the previous administration and in the repeated actions of members of the House, which those members' own party have refused to condemn. This act uses proven methods and existing infrastructure at the State Department to monitor and address religious discrimination and violence. Passing this bill will help the United States continue and reclaim its position as a world leader in promoting civil society, peace, human rights, and religious tolerance. So wholeheartedly support the act. Thank you.
Thank you. Mr. Morelli.
Thank you, Mr. Chairman. First of all, let me thank my longtime friend and the distinguished gentleman from New York for his great work and for being here this morning, and to the ranking member. And I do find that I think about these things, religion is man-made, and we are now still observing a family dispute between Abraham's sons, Isaac and Ishmael, in the religions they created thousands and thousands of years after the establishment of Judaism and Islam. And people's faith continues to divide us, and that's sad and troubling, in the fact that people still prosecute and persecute people of different religions is hard to imagine in the 21st century. But I'm more interested, and perhaps the chair can help educate me, in terms of precedents for special envoys and precedents for the kind of action that you're suggesting we take today in the State Department. Have there been envoys and offices created in the past to address similar types of situations?
Yes, nothing more recent than a special envoy to combat anti-Semitism. I would hope that, and we're waiting for the Senate, of course, to pass it. But that is a precedent-setting piece that I think that we need to make sure it's passed. I hope the Senate passes it soon. I hope we get this bill out and passes it to deal with the scourge of anti-Semitism and Islamophobia.
And do you happen to recall the level of support from members on both sides for that resolution, for the creation of that office? Was there bipartisan support for that?
Absolutely. A very strong bipartisan.
Near unanimous?
Near unanimous.
Was there any, do you recall during the discussion, I think you were probably on the committee, you may not have been, were you the chair when we did that, or was that prior to your?
That was prior to my chairmanship.
Yeah, but you were on the committee, certainly. Do you remember much discussion around the definition of what anti-Semitism was?
In fact, there was no discussion.
No discussion. So it was generally assumed that people understood what anti-Semitism was.
That is correct.
Are you surprised that there's questions about what the definition of Islamophobia might be then?
I am not only surprised, I'm shocked.
Yeah, I'm shocked too. It seems to me seems relatively obvious what it is. Mr. Chairman, I just reflect on, as anyone could tell from the transcripts of my college education, I was not a particularly good student at the State University of Geneseo, and they generously awarded me a degree despite that. But I took Philosophy 101, and I remember one of the fallacies of logic was to oppose a position based on the person who holds such a position. And I have to admit that that to me, and this has been discussed sort of just on the periphery here, that part of the challenge here and part of the opposition from some members of the House and some members of this committee has far more to do with who authors the position and who holds the position more than the actual position itself. And I think not only does that violate logic, I think it violates the tenets and the basic principles of what we do as members of Congress. And so I will support the rule and the underlying legislation. Again, thank the gentleman for his good work, and I will yield back to the chair.
Thank you, Ms. Ross.
Thank you, Mr. Chairman, and I will be brief. I'm a lawyer as well, and just to let you know, most of the time when something isn't defined in statute, what the court does is look it up in the dictionary. And so, not surprisingly, when I just looked it up in the dictionary, Islamophobia, hatred or fear of Muslims and Islam. I don't think any of us would be confused by that. And I don't see the need to insert a definition of something that's in the dictionary in every single statute we have. So we all know what this is about. I'm particularly heartened that this piece of legislation was brought to us by a Muslim member and a Jewish member in concert to take care of this issue abroad, as the chairman has said, and hopefully take care of this issue domestically and within our chamber. And I commend this to you, I commend the rule, and I yield back.
Mr. Neguse.
Hello, Mr. Chairman. Can you hear me?
Yes.
Great. Well, I just briefly want to echo the remarks of my colleagues. I certainly support this resolution and think that this special deploy is a positive first step. I agree with the comments made by Mr. Morelli with respect to the initial conversation that the committee has been having. Anyone can Google Islamophobia and come upon the Merriam-Webster dictionary definition of the term. I don't think there's really any serious debate about what Islamophobia is or how it's been defined, and nor do I think that that would be a valid reason to oppose the resolution. However, I do want to say I have great respect for the gentleman from Texas, the ranking member, and I want to thank him for something that he said today, this morning, something that Leader McCarthy has refused to do, which is to condemn the remarks made by my Colorado colleague that Mr. Perlmutter referenced earlier. And I certainly hope that other colleagues follow his lead. With that, I yield back.
Thank you.
Thank you.
Mr. Chairman, I just want to correct the record. I said in response to Mr. Miller that the Senate was awaiting passage of the bill, awaiting the Senate's confirmation of the special envoy that was nominated.
Yeah. And my understanding on that is that there are some Senate Republicans that are refusing to allow there to even be a hearing on her nomination, which is, again, I don't, when I say that everything gets politicized around here, that's an example of it. Let me say to both Chairman Meeks and Ranking Member McCall, thank you for being here. Thank you for all the work that you do together and the work that you do on human rights. I work with both the Chairman and Ranking Member McCall on our Uyghur Forced Labor Prevention Act. I appreciate your leadership and your consistency on those issues. I mean, there are opportunities where we are able to come together, and hopefully that will bear fruit today or tomorrow. But let me just close by saying I worry that human rights are becoming politicized in this chamber. I mean, human rights are human rights are human rights. I mean, when people are persecuted or their human rights and their dignity are taken away from them, I mean, it doesn't matter, who we're talking about. We all ought to be united in condemning that and making it clear that this country, if it stands for anything, stands out loud and foursquare for human rights. And so I hope that maybe by the time this comes to the floor, that maybe there'll be a bipartisan vote, but I think it's the right thing to do. And so I thank you both, and there are no other questions, and you are free to go. So thank you very much. And this closes the hearing on H.R. 5665. And now I'd like to welcome our witnesses to provide testimony on a resolution recommending that the House of Representatives find Mark Meadows in contempt of Congress for refusal to comply with a subpoena duly issued by the Select Committee to investigate the January 6th attack on the United States Capitol. And I do, before I introduce, okay. Let me just make a few comments, and I'm happy to yield again to the ranking member if he has any additional comments. Basically, what we're talking about today is a measure that calls for the House to hold Mark Meadows, the President Trump's former chief of staff in contempt of Congress for defying a duly issued subpoena and to refer the matter to the U.S. Attorney. And I don't think anybody here takes that step lightly. Mr. Meadows once agreed to cooperate. He produced documents, but eventually changed course and refused to show up for a deposition. He even refused to answer questions as his book was being released, in which he publicly recounts private conversations he had with President Trump. I think, he's fine with doing interviews on Fox News. I guess that's okay, apparently, but he feels that he can't testify before Congress. From the information he turned over to the committee before his stonewalling has made clear he has knowledge and information that is central to this investigation. He's already provided a PowerPoint that, to me, amounts to essentially a paper trail on how to undo the results of an election in the United States. A coup by PowerPoint. It talked about the president declaring a national security emergency and seizing ballots over complete nonsense. President Trump lost the election, period. And a retired U.S. Army colonel who helped circulate the document has come forward and said he visited the White House and spoke to Mr. Meadows 8 or 10 times. I mean, is anyone on the other side shocked by this? Are there people in the Republican conference who are curious about how this thing was drafted or what other information could be out there? I mean, this is stunning. Yet somehow Mr. Meadows thinks he shouldn't have to testify before Congress and answer questions. Give me a break. The texts sent to Mark Meadows that were released by the Select Committee last night were nothing short of a bombshell. The top personalities on Fox News who are today trying to cover up the gravity of what happened on January 6th knew who to go to stop the insurrection that day. The president's son knew who to go to. When Don Jr. texted that, quote, "It has gone too far and gotten out of hand," end quote, what was it that he was referring to? The it was the attempt to overthrow the election. The it was the attempted coup in the United States of America. Yet the president did nothing in those critical moments in what the vice chair has rightly called his supreme dereliction of duty. So based on what we've already seen, I shudder to think what else Mr. Meadows is trying to hide. What we already know and what is already clear is that there was an attempted coup that day, aided and abetted from the top down. You know, if you look at world history, the first attempt at a coup doesn't always prevail, but the next time it often does. If we don't get to the bottom of what happened on January 6th, if we don't prevent it from ever happening again, the next time America may not be so lucky. And just let me remind my colleagues of one thing here. This Capitol was attacked. The people who work here were directly threatened. People died. 140 police officers were injured. It took over 3 hours for the people around Donald Trump to get him to respond. Over 3 hours. Let that sink in. Think of all that happened because of his silence. Think of what could have been prevented had he intervened earlier. I mean, I have a tough time trying to figure out what kind of rotten person would stand by while this carnage was happening before his very eyes, while he was watching it on TV. It's sick. But here we are today, and I appreciate the committee's work and determination to get to the truth. And speaking for myself, I will do whatever I think is appropriate and necessary to make sure that you get all the support that you need, because the American people are expecting us to get this right. I don't know if the ranking member has anything to say, but I'm happy to yield to him.
Just quickly, and thank you, Mr. Chairman. worth noting that, and we'll talk about this, I'm sure, during the testimony. I look forward to that. Mr. Meadows has, submitted literally thousands of pages of documents. And there was, and maybe still is, for all I know, and again, I'll look forward to hearing what the chairman and the ranking the vice chairman has to say about that. Discussions as to whether it's appropriate. There are legal proceedings here underway as to what the extent of executive privilege here is and what it applies. So I guess that's my big concern is, number one, is this exercise going to get us the information that I know you want and the cooperation, or does it make it less likely? And number two, do we have a legitimate legal question here that we ought to resolve before we proceed with criminal contempt? Doesn't mean the committee shouldn't continue its work, doesn't mean they shouldn't be aggressive in pursuit of the truth, but it does raise some interesting questions and as to whether or not we're going too far, too fast here in this particular action. I think we've seen a couple of occasions of that before. So with that, I'll yield back to you, Mr. Chairman, and look forward to the testimony we're about to hear.
Thank you, and I welcome our witnesses to provide testimony on this resolution. Again, recommending that the House of Representatives find Mark Meadows in contempt of Congress for refusal to comply with a subpoena duly issued by the Select Committee to investigate the January 6th attack on the United States Capitol. Chairman Thompson and Vice Chair Cheney, we're delighted to have you here. I now recognize the gentleman from Mississippi, Mr. Thompson.
Thank you very much, Mr. Chairman, Ranking Member Cole, members of the committee. Thank you for the opportunity to testify today. This is an unfortunate situation we're dealing with today, particularly because it deals with a former colleague, and that situation has been made worse by the amount of dust that's been kicked up to try to distract us from the facts. So let me spell out those facts. The Select Committee sought records and testimony from Mr. Meadows because we believe that he had information relevant to our investigation. He reportedly participated in or witnessed events that are the focus of our work. So on September 23rd, we issued a subpoena for documents and his testimony. After weeks of back and forth with his lawyer, evidenced in the letters we made public with our report, we set a November 12th date for his appearance at a deposition. At that point, he hadn't produced any records, and when the time came, he didn't even show up. We signaled at that time that we were prepared to move forward with contempt proceedings, but we also gave Mr. Meadows a final opportunity to reverse course. We set another deposition for December 8th, and Mr. Meadows initially agreed to provide testimony. Now, throughout this process, Mr. Meadows' attorney has raised claims of executive privilege and so-called absolute immunity. The idea that individuals who hold or held certain positions have no obligation whatsoever to appear before Congress when called. We don't accept those claims. President Biden hasn't asserted executive privilege or absolute immunity regarding Mr. Meadows' testimony. And all the courts that have considered claims of absolute immunity have rejected them. But all that discussion about different privileges is a distraction. That's not what this contempt referral is primarily about. This referral centers on the information that even Mr. Meadows and his attorney says is outside all those claims of privilege. He provided roughly 9,000 pages of records that he and his attorney freely admit cannot be held back by any sort of privilege claim. They gave us a lot of this information. His participation in a January phone call aimed at pressuring state legislators to overturn election results, that's not protected by executive privilege. His communications with Georgia Secretary of State regarding efforts to disrupt election, that's not protected. The list goes on, and while the records he handed over gave us valuable information, they also raised a lot of questions. And then the day before he was scheduled to appear for his deposition, he changed his mind. He said he was through cooperating with our probe. He refused to come in and answer questions about the non-privileged material. He has no basis to refuse to cooperate on those matters. That alone is sufficient to advance the referral. But for the sake of argument, let's talk about Mr. Meadows' privilege assertions. The Select Committee isn't able to assess whether Mr. Meadows is making those assertions in good faith because he won't even come in and address them on a question-by-question basis as he's required. I have my view of whether he's made these claims in good faith because I've seen him on television talking about his conversations with the president and promoting his book. I understand that this is a difficult matter. I have no great desire to be here seeking consideration of this contempt referral. Mr. Meadows was a colleague for more than 7 years, but that doesn't excuse his behavior. If anything, his time as a member of the House should make him more aware of the potential consequences of defying a congressional subpoena. We've given Mr. Meadows every opportunity to cooperate with our investigation. We've been more than fair. He's brought this situation on himself, but there's no doubt in my mind that he's in contempt of Congress and has to be held accountable. I thank you, Mr. Chairman, for allowing me to open with these comments, and I look forward to your questions and yield back.
Thank you very much. I now recognize Vice Chair Cheney.
Thank you, Mr. Chairman, and thank you, Chairman Thompson, Ranking Member Cole, and all the members of the committee. As the chairman said, it gives us no pleasure to be here again, and to be here dealing with the recommended referral of criminal contempt of a former colleague of ours. We understand it's a serious matter, and it's a step we wouldn't be taking if it weren't necessary. We don't take it lightly, and we hoped we would not have to be here at all. As the chairman noted, we'd engaged in weeks and weeks of discussions with Mr. Meadows' counsel. We'd worked very diligently to try to reach agreement on cooperation. We'd scheduled a deposition at a time and a day of Mr. Meadows' choosing. But shortly before the deposition was to occur, Mr. Meadows walked away from his commitment to appear, and he informed us he would no longer cooperate. As the chairman noted, we think Mr. Meadows is improperly asserting executive and other privileges. But this contempt proceeding relates principally to Mr. Meadows' refusal to testify about the text messages and other communications he admits are not privileged. He has not claimed, and he doesn't have any privilege basis to refuse to answer our questions about these texts and about these topics. I'm just going to talk about 3 areas that are critically important to our investigation, about which Mr. Meadows has turned over materials that are non-privileged and about which he's compelled to answer our questions. As the violence was underway on the 6th, it was evident to all. But we know that for 187 minutes, President Trump refused to act. And he refused to act when his action was required, it was essential, and it was compelled by his duty, compelled by his oath of office. Mr. Meadows received numerous text messages that he has produced without any privilege claim urging President Trump to take action. I read a number of those last night to the nation. Here are a few others from Republican members. Quote, "It is really bad up here on the Hill." Another one, "The president needs to stop this ASAP." Another one, "Fix this now." And as we saw last night, dozens of texts, including from Trump administration officials, from members of the press, from Donald Trump Jr., urged immediate action by the president. But we know hours passed with no action by the president to defend the Congress of the United States from an assault while we were trying to count electoral votes, which was an official proceeding. This brings up another point. Mr. Meadows' testimony will bear on a key question in front of this committee. Did Donald Trump, through action or inaction, corruptly seek to obstruct or impede Congress's official proceeding to count electoral votes. Mr. Meadows' testimony will inform our legislative judgments on those issues. But Mr. Meadows has refused to give any testimony at all, even regarding non-privileged topics. That puts him in contempt of Congress. And let me pause and just note that we as Republicans used to be unified on this point in terms of what happened on January 6th and the responsibility the president had to stop it. We all remember, every one of us, what Republican leader McCarthy said on the floor of the House the following week. Quote, "The president bears responsibility for Wednesday's attack on Congress by mob rioters. He should have immediately denounced the mob when he saw what was unfolding. These facts require immediate action by President Trump." That was Republican leader McCarthy. Mr. Meadows has also got knowledge regarding President Trump's efforts to persuade state officials to alter their official election results. In Georgia, Mr. Meadows participated in a phone call between President Trump and Georgia Secretary of State Raffensperger. He was on the phone when President Trump asked the Secretary of State to, quote, find 11,780 votes to change the result of the election in Georgia. At the time of the call, Mr. Meadows, according to texts he has turned over, appears to have been texting at least one other participant on the call. Again, Mr. Meadows has no conceivable privilege basis to refuse to testify on that topic, and doing so puts him in contempt of Congress. Finally, in the weeks before January 6th, we know that President Trump's appointees at the Justice Department told him repeatedly that his claims of election fraud were not supported by the evidence. They told him the election was not, in fact, stolen. President Trump intended to appoint Jeffrey Clark as Attorney General, in part so that Mr. Clark could alter the Department of Justice's conclusions regarding the election. Mr. Clark has now informed the committee that he anticipates potential criminal prosecution related to these matters, and he intends in upcoming testimony to invoke his Fifth Amendment privilege against self-incrimination. As Mr. Meadows' non-privileged texts reveal, he was communicating multiple times with a member of Congress, a currently serving colleague of ours, who was working with Mr. Clark. Mr. Meadows has no basis to refuse to testify regarding those communications. He is in contempt. January 6th was without precedent. There has been no stronger case in our nation's history for a congressional investigation into the actions of a former president. We must investigate the facts in detail, and we are entitled to ask Mr. Meadows about the non-privileged materials he has produced to us. Any argument that the courts need to resolve privilege issues first is a pretext. We need to question him about emails and texts he has given us without any privilege claim. His role in the Raffensperger call cannot be privileged, nor can his dealings with a member of this body regarding Jeff Clark. We must get to the objective truth and ensure that January 6th never happens again. I urge my colleagues to support this resolution, and I yield back.
Well, thank you very much, and thank you both for your testimony and for the work you're doing. Maybe former Chief of Staff Meadows should talk to former Congressman Meadows. When he was serving here, he complained about subpoenas being ignored, information being hidden, and Congress being stonewalled. When it came to other people facing a congressional subpoena, he said, and I quote, "They may be able to ignore Congress, but they won't be able to ignore the American people," end quote. So I don't know what changed when he moved from working for one branch of government to the next. Maybe he's just that afraid of Donald Trump, but there are not two systems of justice in this country. No one is above the law, and again, the more and more we reflect on what happened on that terrible day, the more and more I am stunned by the stonewalling of people close to Donald Trump. The American people deserve to know what happened and who was responsible. Again, a lot of time went by before the president finally intervened. And you know, lots and lots of, I mean, we're seeing some of the texts that were released from Republican lawmakers and others, you know, texting to Mr. Meadows, we're under siege up here at the Capitol. They've breached the Capitol. Marked protesters are literally storming the Capitol, breaking windows on doors, rushing in. Is Trump going to say something? There's an armed standoff in the House chamber, at the House chamber door. We are all helpless. And, you know, even some Trump administration officials, you know, POTUS has to come out firmly and tell protesters to dissipate. Someone is going to get killed up here. Mark, he needs to stop this now. Tell them to go home. POTUS needs to calm this, I can't repeat it here, down. I mean, even people, and you released this yesterday, in the very conservative news media were begging that there be an intervention, that the president put an end to this. And he didn't. It took hours. You know, I really believe that, you know, they say that sometimes, you know, coups don't succeed the first time, but there could be a second or a third time. I mean, what happened that day was so wrong, and the president and some around him behaved in such a way that, quite frankly, everybody's life was endangered here on the Capitol campus. You know, staff, you know, people who worked in our cafeterias, people who, the Capitol Police, you know, who were, I mean, who were injured, and some died. And you know, at some point, you know, enough is enough, and there needs to be a full accounting, and we all need to come together around this. And I get it. I mean, you know, the politics is involved in everything we do up here, but this was just so wrong. And if the goal by some is to wait out the clock, to try to invoke stalling tactics so we don't ever get to the finish line, that's a terrible tragedy for this country. And you know, we were there. Many of us were there on the floor that day. I was in the chair that day. And when I walked out into the speaker's gallery, I came face to face with this angry mob smashing the doors to get into the speaker's lobby. I couldn't believe it was happening here. I never thought such a thing would ever happen up here. And for people to try to minimize that, or to try to invoke delaying tactics, you know, or to try to characterize it as something that it was not. This was not a group of people interested in protecting our democracy. This was a group of people trying to destroy our democracy. So you know, I regret that we have to be here and invoke the measures that we're about to do, but I mean, this is serious business, and I commend you both for your efforts here. And but again, I think that we need a full accounting of what happened, and we need to understand why the president waited so long. Hours, you know, hours went by before he finally decided to say anything. So I thank you. I have no questions. Mr. Cole.
Thank you, Mr. Chairman. Mr. Chairman, I wanted to introduce a letter that was sent to the council by the council from Mr. Meadows to Mr. Thompson, Chairman Thompson, and the other members of the Select Committee on December 13th, and just to ask unanimous consent
Without
to enter
objection.
it into the record. Thank you very much. Mr. Chairman, did Mr. Meadows write you on October the 6th to request the Select Committee identify topics which he might be able to provide useful, non-privileged information?
I'm certain he did, if you're referring to a letter.
Yeah, I'm sure you're right. Did you engage in accommodations process to narrow the scope of the subpoena? Was that a serious back and forth discussion?
Well, we've been back and forth with Mr. Meadows' counsel since September on various issues. At no point did we refuse to engage in.
Did you ever seriously consider, or was your subpoena absolute, or were you willing to say, yeah, there are some privileged areas here that perhaps are beyond what we should be
Well,
inquiring?
the subpoena spoke for itself, Mr. Ranking Member. What we tried to do was to accommodate his counsel on any questions to the extent practicable. That was what we did.
Okay. On November 3rd, didn't Mr. Meadows write again, stating he was, quote, willing to explore with the Select Committee whether outside the confines of the subpoena an accommodation could be reached by which he might be able to answer under agreed-upon appropriate circumstances a limited set of questions that would further a valid legislative purpose within the scope of the Select Committee?
Well, you know, the subpoena required a deposition, and we have, as a committee, sought to depose him pursuant to that. Now, we can negotiate around some other issues, but he has to sit for the deposition.
And can that deposition be limited in any way before you sit down? Isn't that the purpose of the negotiation, to see, okay, there's non-privileged matters that certainly, and as you suggested in your testimony, and he clearly thought there were areas that were non-privileged that were appropriate for the committee to be asking about.
Well, if he felt there were areas that would be outside, then he could put them forth at that proper time, but we felt that he needed to do it at the deposition.
Okay. After additional exchanges of letters, you wrote to Mr. Meadows on November 9th, unilaterally stating that, quote, it appears the accommodation process has reached its natural conclusion, yet Mr. Meadows was still seeking to define the contours of accommodation. Is that correct?
That's correct.
Okay. What legal standard did you use as the basis for your decision to decide, despite ongoing correspondence, that the accommodations process was over?
Well, the legal standard was the fact that every person that has offered testimony to the committee, we've tried to work with them. But it's the committee's standards that we adhere to, not the other individual.
Okay, on November 19th, did Mr. Meadows send you a letter to clearly communicating a list of topics on which he was willing to provide responses to written interrogations?
Well, in all deference to Mr. Meadows' counsel, then, you know, he can say it, but it's left up to us to accept it as a committee.
Mr. Chairman, could I'd like to make sure that we enter into the record all of the committee, all of the chairman's responses to Mr. Meadows' attorney, because in addition to what the ranking member is referring to, the committee has engaged with Mr. Meadows' counsel multiple times, providing with him lists of topics about which we'd like to question him that are clearly non-privileged. And if he has a privilege claim he needs to make, he needs to appear and assert it on the record. But his refusal to appear at the deposition that was scheduled when he requested it be scheduled at the end of multiple exchanges back and forth made his assertion of that privilege on the record impossible. And he has never indicated to us any justification for his refusal to appear to discuss non-privileged materials, and that's because he has no basis for which to refuse to appear to discuss those materials.
Without objection.
Okay, Mr. Chairman, has Mr. Meadows provided you with 1,139 documents, 6,836 total pages, and a privilege log for any documents withheld?
He has provided the committee with a number of documents.
Okay, did Mr. Meadows also provide 2,319 text messages and a metadata from his personal cell, and 20 documents from his personal computer, and a privilege log for any withheld text messages?
Well, to the extent that the numbers you quote are correct, those documents are what we have. The question, Mr. Ranking Member, for a lot of us is, now that we're in receipt of those documents, we wanted to talk to Mr. Meadows about them, and that's why we wanted to get him before the committee for deposition, and he's refused to come.
On the subpoena in question, did the committee issue it for law enforcement purposes or legislative purposes or both?
I would say for legislative purpose.
Okay, that's what I assumed. During our hearing on the Jeffrey Clark criminal contempt resolution, you and your colleagues repeatedly said that Clark could not raise executive privilege pursuant to Trump versus Thompson because Clark was not the one in court, but Mr. Meadows is in court, is that correct?
That's correct.
Okay. And well, again, during the same hearing, you and your colleagues repeatedly referred to the need for document production in order to continue your investigation. If that's, and I'm sure that is the case, but then why are we advancing a measure here that's purely punitive? That is, the committee's not pursuing civil enforcement of the subpoena. Why not the civil course? Why the criminal course?
Well, clearly the criminal choice is what the committee made. We see the lawsuit merely as a delaying tactic on the part of Mr. Meadows, and we have given him, as I've said earlier, every opportunity to come to the committee. We negotiated with him, and at the last moment, he said he's not coming, and then he filed suit, which is his choice. We don't have to, as a committee,
Yeah,
to
no,
honor the suit.
again, I'm just trying to be clear on this because you clearly had a choice to make, and I think when you choose the criminal course, you assure you're not going to get cooperation. When you choose the civil choice, you might. So I'm just trying to understand why not try that first, civil contempt, as opposed to criminal contempt.
It was a decision that the committee made to go the criminal route.
Okay. Thank you very much, Mr. Chairman. Thank you, Mr. Chairman. I yield back.
Thank you. Mr. Torres. Dr. Burgess.
So, Mr. Thompson, just to your last statement, that there was a choice that the committee made to go the criminal route and not the civil route. Did you have a hearing? Did you take a vote on that?
Well, we take a vote on everything we do as a committee. The committee looked at it, the choices. Obviously, we could do a number of things. We could do nothing. But we felt in the interest of getting as much information as we could, we pursued the criminal route. It's the more expeditious route. The civil would probably end us up in the years of litigation, which would delay the work of the committee.
So is your ultimate goal for a criminal referral to a branch of law enforcement because you don't have the force of the Department of Justice?
No, once we pursue the criminal, it's out of our hand. It's Department of Justice effort after that. We've done it one other time and successfully. But if Steve Bannon decides to defend himself in court, that's independent of our committee. Our goal is to try to get to the facts and circumstances that brought about January 6th.
Okay, to that point, let me just ask you, are there other documents you're pursuing to get to that end, to achieve that end? Are you looking at correspondence and emails from the mayor of Washington, D.C. to the decision to not have protection here on the Capitol?
Yeah, well, the mayor is scheduled to testify before our committee. So, I mean, if you know of someone that we ought to bring before the committee to testify, our process has been open. we get suggestions from a number of people.
Well, I will give you these two suggestions. The Speaker of the House and the Senate Majority Leader, Mr. McConnell, had the obligation of protecting the Capitol that day. As a member of Congress, I'm extremely interested in what data they sought, what if there are discoverable items in emails or texts or other documents. I expect your committee to pursue it with just the amount of vigor they're pursuing what many of us see as a purely political process. If you really want to get to the answers, if you really want to protect the Capitol against any future attempts, as Mr. McGovern keeps alluding to, why would you not go to the source, the two people who are tasked with the protection of this institution?
I'll yield to the Vice Chair.
Thank you very much.
Well, wait.
The committee
The question is to the chairman.
Well,
You're in charge of this investigation.
I'd like to add something, Mr. Burgess. I'm sure you won't mind if I do, in the interest of transparency and getting to the facts. Our investigation, as the chairman has noted multiple times, is very broad, gets at exactly the issues you've described. I'd be happy also to forward you the Senate report that has already been completed on those issues, on which we are adding. The issues around the security at the Capitol is critically important. I take issue, though, you describe go to the source. I don't believe that it is your view. I'd be stunned, frankly, if it is, and certainly the facts and the evidence do not bear out the notion that the source of the attack on January 6th was somebody here in the Capitol. This investigation has got to include what happened with respect to intelligence, what happened with respect to law enforcement, what happened here at the Capitol. But there is no doubt that the summoning of the mob to Washington, the provocation of the attack on the Capitol, and the 187 minutes during which we were under violent attack and President of the United States refused to act are indeed critically important areas where, for legislative purposes, which have been affirmed by both the Federal District Court for the District of Columbia and the Circuit Court for the District of Columbia, we have valid legislative purposes to get this information. And I think that with all due respect, my colleague fully understands that.
You know, I don't think that's an accurate assessment. I was aware of people talking just amongst themselves here in the Capitol, the day of the swearing in, the day after the swearing in. Are you worried about what's going to happen later in the week? Do you know about the people that the Proud Boys are going to be here? I did not know. Can't say that I actually knew who the Proud Boys were. But these were topics of general discussion going on here. So if you know that, and look, we've had bad protests here at the Capitol before. I was here when the Affordable Care Act went through the legislative process. You don't think we had some really upset people outside the Capitol during those days? Of course we did. It's what we do here. But where was the preparation for what everyone seemed to know was coming? Why did it stop? And that is the question that I hope.
Will the gentleman yield? Will the gentleman yield?
No, I will not. This is important. This is the question that I hope you, as an investigative committee, if you were to do your work, Mr. McGovern keeps talking about the next one, the next one, the next one. Let's protect ourselves against the next one by understanding where the deficit were prior to this one. And Mr. Chairman, I just ask a copy of the letter from the mayor of Washington, D.C. to the acting U.S. Attorney General and the acting Secretary of Defense be made part of the record.
Without objection.
And I'll yield back.
I think, did you want to respond? Yeah,
Well, let me just say that I don't know how you can draw a comparison between the Affordable Care demonstration and what occurred on January 6th. Right. I mean, people broke into this institution. They harmed people. They did all kinds of things. Look at any video, Mr. Burgess, that you want to see. This is not the America that we live in. I am thoroughly concerned that for some reason, people did that. And with House Resolution 503, we are tasked with the responsibility of looking to the facts and circumstances of what happened. So I say, if you have additional witnesses you want to suggest, get it to us. But we'll do our work. We'll produce a defensible product based on the facts and circumstances behind what we come up with. And it's not going to be easy, because just like Mr. Meadows started off engaging the committee and stopped in midstream. I don't know if it was the former president saying what he was saying and what he put in his book was fake news, but he stopped right in the middle of an effort that our committee legitimately started negotiating with him. And after former President Trump made the statement, fake news, we never got another word from Mr. Meadows.
Mr. Perlmutter.
Article 3, let's see, Article 2, Section 1. This is the President's oath. I do solemnly swear that I will faithfully execute the office of President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. Then Article 6, Clause 3, for all of us, we shall be bound by oath or affirmation to support the Constitution. We all take an oath. I do solemnly swear that I will support and defend the Constitution of the United States against all enemies, foreign and domestic, that I will bear true faith and allegiance to the same, that I take this obligation freely without mental reservation or purpose of evasion, and that I will well and faithfully discharge the duties of the office on which I am about to enter. So help me God. You know, I'm surprised, because I think what we're going to get next from Mr. Meadows is probably something like we got from Mr. Clark about the desire to take the Fifth Amendment. Because 18 U.S.C. 115, following, Article 3, Clause 1, treason against the United States shall consist only in levying war against them or in adhering to the enemies, giving them aid and comfort. Treason is defined, going back to dictionary. Treason is the crime of attacking a state authority to which one owes allegiance. And what you've described is the minute Donald Trump said fake news, all of a sudden everything stops because there's a pledge of allegiance to Donald Trump above and beyond the Constitution here, which really is frightening. And 18 U.S.C. 115, which is why I think that we're going to see the Fifth Amendment being pled, whoever, owing allegiance to the United States, levies war against them or adheres to their enemies, giving them aid and comfort within the United States or elsewhere, is guilty of treason and shall suffer death. I mean, this is a death penalty statute. Or shall be imprisoned not less than 5 years and fined under this title but not less than $10,000, and shall be incapable of holding any office under the United States. And just the memos that have been disclosed to this point, in my opinion, are treasonous. And we've danced around this a lot, and we talk about obstructing Congress and things like that, but this was an effort to have a coup, to overthrow the country, to break the pledge of allegiance we make to this country and to the Constitution. I really am disappointed in Mr. Meadows. We always had a good working relationship here. He has two masters, Donald Trump and the United States of America, and I could see he's in a pickle about that, but it's the United States of America and the Constitution of the United States to which he owes allegiance, and I hope that he will fulfill his oath that he took as a member of Congress and the oath that he takes as an officer of the federal government to uphold the Constitution. With that, I yield back.
Thank you. Ms. Fishbach.
I'm just going to associate myself with the comments of the ranking member, and I will have questions for Mr. Armstrong when he arrives.
Okay, thank you.
Thank you.
Mr. Raskin.
Thank you, Mr. Chairman. After producing 9,000 pages of documents and saying he would comply with the committee subpoena, after agreeing to come and testify, and after extensive cooperation with the committee, Mr. Meadows' book, The Chief's Chief, came out, and President Trump exploded and called it fake news. And Mr. Meadows amazingly echoed that and agreed that it was fake news, and then he said he would no longer participate. He would not come and testify, to the astonishment of everyone on the committee, after saying he would come forward. Then he goes to court as a delaying game, as you say, Mr. Chairman, to try to throw a monkey wrench into the process he'd been cooperating with up until Donald Trump blew his top. His central argument there is that we have no legitimate legislative purpose in conducting this investigation. Okay, so that's the heart of the matter. I want to read to you guys Article 1, Section 8, Clause 15 of the Constitution under the powers of Congress. Congress has the power to provide for calling forth the militia to execute the laws of the Union, to suppress insurrections, and to repel invasions. Mr. Chairman, what do you make of the claim that the Congress of the United States, the House of Representatives, does not have the power to investigate a violent mob attack on the Capitol of the United States? What happened, how it got started, who paid for it? What do you make of that claim?
Well, I think it's just patently wrong. Clearly, H.R. 503 gives us the authority as a committee to look at all the facts and circumstances surrounding January 6th. And that's what we're doing.
Oh, it's very clear that House Resolution 503 commands us to do precisely what the committee is doing, but he's suggesting that it's somehow unconstitutional, that the Congress doesn't have the authority to investigate an attack on the government of the United States, an attempt to overthrow the election. Madam Vice Chair, what do you think about that claim?
Well, I think it's wrong, and I think the federal courts have also made very clear, just in the last 2 weeks or 3 weeks, that in fact the committee has stated a completely appropriate legislative purpose. So it's not an issue anymore.
Judge Chutkin, in looking at former President Trump's arguments, said presidents are not kings, and the plaintiff isn't president. Mr. Chairman, this really goes to the heart of our system, doesn't it? Do we have kings here? Do we have lords and nobles and friends of presidents who don't have to respond to congressional subpoenas or court subpoenas if they don't want to?
It is not up to individuals. We're a nation of laws, and clearly, because we're a nation of laws, people have to respect those laws and follow them.
Ms. Cheney, do we have to remind some of our friends what the American Revolution was about and what our Constitution says? Does our Constitution allow for kings, nobles, lords, people who are above the law?
Certainly it does not. No one's above the law. We're a nation of laws. And I'm just so struck, frankly, by something my colleague from Texas said a few moments ago in talking about the attack on January 6th, when he said, quote, "It's what we do here." No, it isn't what we do here. That's not what we do here. We can have debates and discussions about the law, about policy, about what is an appropriate role, but January 6th is not what we do here, and it can never be what we do here. And we have an obligation and we have a duty to ensure that the functioning of the government, the official proceedings of Congress, and it's difficult to imagine a more important official proceeding of Congress than counting electoral votes, that those who might attempt through either action or inaction to obstruct or delay those proceedings, that we get to the facts, that we understand what our legislative role is in protecting this nation, protecting the Constitution, protecting this Congress from making sure that ever happens again.
Mr. Chairman. Mr. Raskin, I'm from a part of this country where Congress had to pass laws so that people of color could vote. Because in my area, even Benny Thompson getting elected, it took a Voting Rights Act for that to occur. I'm a third-generation person in this same little community I represent, but there has to be a place for our federal government when all else fails. And what you saw on January 6th was an absolute failure on the part of a lot of systems. And those systems are under review right now. So bringing witnesses to our committee, seeking testimony from individuals who have information, we are absolutely open to that process. We are not trying to tailor it in a particular direction. We want to get to the facts and circumstances. There's no ifs, ands, and buts about it. But the buck stops with our committee to come with an objective report based on the facts. And
Hey, haven't you overseen something like 300 witnesses coming in either voluntarily or under subpoena, complying with the requests of the committee? The vast majority of the people have participated, right?
Only 3 people at this point of the over 300 has not.
Ms. Cheney, the claim that a former president is not subject to legal process is extremely far-fetched, given the Supreme Court has found that the sitting president is subject to legal process. Do you remember a 1997 decision in a case called Clinton versus Jones? Remember the Paula Jones case?
I do.
And you remember the Supreme Court saying that the president of the United States, who's in office right now, is subject to civil suit? Is there any reason to believe that a former president is not subject to legal process, or even worse, that he can wave a magic wand and keep other people from having to testify?
No, and I think that last point is really critical. There are issues that we are litigating here, there's no question. But people need to remember that the current president, as to many of the matters we are discussing, has waived executive privilege. Mr. Meadows has, in fact, received indication that from the sitting president, from the White House, that he needs to appear, he needs to testify. And we are, as we have said repeatedly, focusing on matters over which he has no ability, no possible claim of privilege. If he would like to assert privilege, he needs to appear and do so. A blanket notion that somehow I've determined I'm not going to appear because of privilege is not proper.
It has no basis in the law, right? Now, as you say, the executive privilege belongs to the President of the United States. Has President Biden come in to invoke executive privilege to stop Mark Meadows from testifying about what took place on January 6th?
No.
He is not.
He is not, right? And has former President Trump, Mr. Chairman, although he has no say in the matter, but has he even tried to come into the committee to block the committee from taking Meadows' testimony? No. Well, does the Constitution, Ms. Cheney, have an office of former president?
No. Now, it is the case that there are some instances where a former president may assert privilege. But in those cases where the current president has made the determination that he will not be asserting privilege, and there is a process that the committee is undergoing, then the former president does not have the power to stop the Congress from investigating an attack on Congress and to prevent people from testifying who have information about that attack simply because, of some notion that he can.
What if it would be embarrassing to him?
Right. Those are not privileges that exist in the common law. There's no basis for that.
Well, you say that a former president can try to raise a claim of privilege, which is exactly what Donald Trump did in Trump versus Benny Thompson. And now we have definitive rulings by the federal district court and by the DC Circuit Court of Appeals panel headed by Judge Millett on precisely that point. And Madam Vice Chair, I'm afraid you stated a little bit too categorically. I don't want people to think that a former president can just assert executive privilege and it works. He can raise the executive privilege as he just did, and he got slapped down so far at every level in the federal courts. And what's the analysis the court goes through? Well, it starts with the presumption, as you do, that under the American rule of law, everybody owes his or her complete truthful testimony to the Congress of the United States if it comes calling with a subpoena, just like in a court. That's the presumption, and the people have the right to know because this is a democracy. Now, what could be countervailing to that is some compelling interest provided by a president sitting, or an extremely compelling interest provided by a former president. And the DC Circuit Court of Appeals, with Judge Millett deciding, unanimously said not only was there no compelling or extremely compelling reason to overthrow the presumption that Meadows had to testify, Donald Trump did not even offer one. He could not even offer an interest. Well, what about the interest in doing this again someday? Is that a compelling interest that a president could incite a violent insurrection against the Union? Do we want to shield any information about that in order to protect a president from doing that in the future, Mr. Thompson?
I would hope not.
Ms. Cheney, what do you think about that?
No, of course not. And I think that the point that you're making is very important for people to understand. We all talk about executive privilege broadly. It's a qualified privilege. And when there is an interest, as there is clearly here, that is a privilege that does not shield entirely from someone's duty to testify. I would also say that we're at the point now where there are many of these details of what happened that we have heard so many times that I think it's really important for people to pause for a moment and recognize what we're talking about. When we say we need to ask Mr. Meadows questions about the President of the United States' effort to make Jeffrey Clark Attorney General, Mr. Meadows' questions about his discussions with members of Congress about that, and about what was at the heart of that determination, the effort to overturn the election results in Georgia and in other states. I mean, those are the kinds of things, if you had said a year and a half ago, I think people would have been stunned. But we have to be very sure that we don't become so accustomed to hearing the really grave details of what this president was doing that we move on from the importance of understanding the specifics and the minute-by-minute of what happened.
Well, and let me close with a couple questions about that, Madam Vice Chair. Last night, the committee invoked a whole set of messages that were discovered in asking questions to Mr. Meadows, including Republican lawmakers and others sending frantic messages saying, "We are under siege up here at the Capitol. They have breached the Capitol. Mark, protesters are literally storming the Capitol, breaking windows on our doors, rushing in. Is Trump going to say something? There's an armed standoff at the House chamber door. We are all helpless." Here's some more. This one came from Laura Ingraham. It was identified. "Mark, the president needs to tell people in the Capitol to go home. This is hurting all of us. He is destroying his legacy." Brian Kilmeade, "Please get him on TV, destroying everything you have accomplished." Sean Hannity, "Can he make a statement, ask people to leave the Capitol?" Donald Trump Jr., "He's got to condemn this excrement ASAP. The Capitol Police tweet is not enough." Meadows responding, "I'm pushing it hard, I agree." Donald Trump Jr., "We need an Oval Office address. He has to lead now. It has gone too far and gotten out of hand." Now, Madam Vice Chair, why is it not sufficient just to say, well, he complied up until the point when Donald Trump essentially told him to stop complying? Why is his testimony further needed by our committee?
Because there are well, first of all, it's compelled by the subpoena. He's required by our subpoena to both produce documents and to answer questions, to appear to testify. And there are a multitude of questions that we need to ask him. We need to ask him, we need to understand what was going on, what were his discussions with the member of this body about making Jeffrey Clark Attorney General. Why did they want to make Jeffrey Clark Attorney General? What did he think about the letter that Jeffrey Clark was proposing to send to state legislators in Georgia to overturn the results of those elections? Why were Fox News hosts texting him, telling him that they needed to get the president out to stop this? Why did they think that the president was the one who could stop this? Because many of those same people now are in fact saying, gosh, this was just tourists. Or this was a false flag operation, another person on Fox News has claimed. So I think there are real questions about what those discussions were. I think there are questions we need to ask about what their plans were, what plans they were making on January 6th, what plans they were making with respect to the vice president, what plans they were making to have the vice president, to get outside legal counsel to tell the vice president that he could in fact decide not to count certain electoral votes. The American people deserve to know all of the steps that Donald Trump, that those around him, that his campaign were taking in an effort to change the results, to overturn the election, to delay the electoral count. And again, the messages that Mr. Meadows has turned over are non-privileged, and he has a duty under...
Everyone agrees to that. No one
Right.
claims. So the executive privilege argument, as the chairman said, is pretty much a distraction at this point, because we're
It's a
talking about
pretext.
questioning him about things that he's already
And
produced.
he has
Yeah.
a duty under the subpoena. He also has a duty as an American citizen, and he has a duty as somebody who served in a position of public trust, who swore an oath under God to our Constitution. He's got a duty to come forth and tell us what he knows.
Thank you.
Well, and the vice chair is absolutely correct. The other thing, Mr. Raskin, is this information was provided by Mr. Meadows to the committee. And what we gleaned from that information was enough that we needed to have him in person to come and explain the information that he had provided to the committee, of which he's denied to come.
Well, let me ask you about it, and I'll close with this question, Mr. Chairman. You know, there's so much cynicism now in the public. Some people would invite us to believe that everything that happens in our politics is just lies, disinformation, fake news. What's the importance of the committee actually trying to establish the facts of what took place?
Well, I think absolutely. That's the core objective of the committee, is to get to the facts and circumstances that we can prove. Now, I think part of what you just read, why would all these people text the President of the United States and say, you have to stop these people? There's some connection between those individuals doing the text and who they're doing it to. And our committee needs to figure out in our investigation what those connections are. And the only way we can prove and get to those connections is have the people who are communicating with that to come before the committee.
You mean they weren't texting you to call it off?
No, sir.
Were they texting you, Ms. Cheney, to call it off?
They were not.
Seemed just to go to Mr. Meadows and the president. I yield back to you, Mr. Chairman.
Ms. Scanlon.
Thank you, Mr. Chairman, and I do want to express our continued appreciation to the members of the January 6th committee for your tenacity, your steadfast patriotism and courage, and your focus on the actual issues before the committee, which would be, why was there an attack on this building, a physical attack on this building, a physical attack on the Constitution on January 6th, and how can we prevent such attacks in the future? And your focus, despite the intense pressure to block your inquiries and attempts to distract, to denigrate the severity of what happened, to deflect, to throw dust in our eyes, I think is what the chairman said. Chairman McGovern referenced the mental gymnastics required to support Mr. Meadows' claim that he doesn't have to testify in response to a congressional subpoena. He's claiming he doesn't have to testify because of executive privilege, that everything he knows was privileged in some manner, and that's simply not true, I think, as you've laid out quite compellingly. It's a distraction because there's no executive privilege from talking about conversations with people who aren't part of the government. There's no executive privilege for conversations about political as opposed to official activity. There's no executive privilege for crimes against the country. So all of this is just a distraction. But also, Mr. Meadows has already admitted that much of what he knows is not privileged. He's turned over these thousands of pages of documents. He's said that privilege protects his conversations with the former president at the same time as he has embarked upon a tour to sell books about his conversations with the former president. And it's so disappointing, so profoundly disappointing that our colleagues across the aisle are engaging in the same mental gymnastics to assist this stonewalling, to assist this cover-up. Last week, we were told that it was premature to start contempt proceedings against Mr. Clark because he had not yet filed a suit to quash the subpoena against him. Today, it's been suggested that it's too late to start contempt proceedings against Mr. Meadows because he has already filed a lawsuit to try to quash his subpoena. As the vice chair suggested, they're flipping the burden of proof with respect to who has to claim privilege here. They're suggesting that the January 6th committee has to guess what elements of unprivileged communication Mr. Meadows has when it's actually his duty to carve out the areas that he can't testify about. So it's all completely through the looking glass at this time. And again, thank you for your patience and for forging ahead on all of this. I think it's increasingly clear that the real and very present danger before this Congress and the country is the ongoing threat to our Constitution and the rule of law posed by the lack of a common understanding, which this committee is tasked with getting, about what happened on January 6th, and accountability, which thus far has been lacking for why that happened. It appears that Mr. Meadows is more afraid of the former president than he is of defying a legitimate subpoena. And that's simply unacceptable. And the fact that some of our colleagues appear similarly frightened of the former president as opposed to standing up for the Constitution is also frightening. The fact that any member of Congress is willing to excuse or support a fiction that this was not a serious assault on our Constitution or that there is any legitimate reason to defy these subpoenas is a fair measure of the threat to our democracy at this point. So again, I commend your efforts. I look forward to supporting this rule and the resolution, and I would yield back. Thank you.
Thank you. Mr. Morelli.
Thank you, Mr. Chairman. And I want to continue to add my thanks to both of you and to the members of the committee for the extraordinary work that you are doing. You know, I'm a bit of a fan of old movies, and I think back to one of my favorite films is Gaslight, the 1944 version. Charles Boyer, tries to convince his wife, played by Ingrid Bergman, that she's insane. He dims the gas lights to make her think she's hallucinating. And that film gave rise to the term gaslighting, the act of making someone question their own reality. And I can't help but think that American citizens are victims of gaslighting, that we are literally questioning, many Americans are questioning the reality of what they witnessed with their own eyes in real time on January 6th. And I know that members have described the attack on the building, the attack on us as members of Congress, but although those are obviously very important, it was more an attack literally on the Constitution of the United States and the Republic. that helps define it. And not only are we asking Americans, some of us asking Americans to ignore what they saw, but as my colleagues have pointed out, the contemporary accounts of people who experienced the events, who wrote text messages, who in the days following condemned what had happened, and yet today seem to have had this amnesia about what had happened, or now frame it in ways that are completely divergent from what they did in their accounts in the days and the hours and days that followed the attack. And I agree also with my colleagues. I think these are the darkest days America has faced, and that our republic is in grave danger, and the work that you're doing will hopefully, I pray, help save this republic. I also want to say, this is completely a digression, and this is Joe Morelli's opinion. I don't know that anybody's written about it. I find it highly inappropriate that a White House chief of staff would publish a tell-all book within 10 months of leaving office, just as a complete aside. I find that so indecent and without honor that it makes me question so many things about what we do. And I would hope there's no precedent for that in the future. But it is, however, insightful in many ways and what was going on at the time. So maybe while I find it indecent that you would do it for financial gain, it does give us a window on what happened. And I also find it mystifying that Mr. Meadows would tell all in a way to gain financially for himself, but isn't prepared to testify in front of Congress in order to save the country and the republic. But I wanted to go back, and I certainly don't in any way want to suggest that my good friend from Oklahoma meant this, but the notion of sort of bringing up the number of texts and documents that Mr. Meadows submitted to the committee does not obviate the need, and I think the vice chair said this, to come and testify. It's not as though in a criminal proceeding or a subpoena by Congress that people can individually just choose, well, I'll submit documents, and I'm not suggesting that the gentleman was suggesting this, but it would lead someone to question, is it necessary then for me to testify when I'm called? I mean, will just the submission of documents suffice? Is that, and I do think the vice chair answered this, so you can certainly feel free to comment further, but there's clearly questions that arise when you get the documents. You want, and I assume this is the whole point of asking someone to testify in any place where a subpoena is appropriate, to answer questions about the documents submitted. Is that not what the whole point of this is?
Well, I mean, absolutely, and for us to take those documents and develop the next line of questioning in person of that individual, of which Mr. Meadows failed to follow through.
And I assume, I haven't seen the documents in question, the texts and the emails and other documents, but I assume they have given rise to probably hundreds of additional questions where the members of the committee and the Congress and the American public should have the right to have the questions about those documents answered. And I don't know, Madam Vice Chair, if you want to comment on that.
Yes, absolutely, you're right, Mr. Morelli. And you also mentioned Mr. Meadows' book. And as the committee described last night, there are many instances in Mr. Meadows' book where he talks about issues that are of great interest to us, including, for example, he recounts a conversation that he had with former President Trump right after the former president urged people to march to the Capitol and told people he would be with them in that march. And Mr. Meadows recounts his conversation after that. So, of course, details like that he is recounting in a book, but then refusing to answer questions before Congress about, there are legitimate questions that he is obligated to appear to provide responses, and failing to do so puts him in contempt.
And I do find, I continue to scratch my head about the notion you would author a book on the subject, sell it to the American public, and not be willing to testify to Congress about the comments you made in the book. It's really astonishing to me that we're here. And I also, my colleagues have raised this, it's almost as though, and I appreciate what people have said, and I don't want to engage in repeating this, but it's almost as though if you engage in treasonous activities in plain sight, and with many of your colleagues gathered around you to engage in that treasonous activity, it's almost as though you think that that's okay, that somehow doing it in plain sight somehow allows that to be an okay thing. That, and I suppose that the precedent that my colleagues have mentioned, that if a future president decides that he is going to be, or she is going to be protected by just invoking privilege, but engages in a pretty wide conspiracy against the United States government and by extension the people of the United States, that would somehow be okay. I mean, I guess you would avoid all accountability if you follow this to its logical conclusion, which I find honestly astonishing. And I'll repeat again, I think these are the darkest days. And I think that it bears repeating by all of us over and over again to our constituents and to the American public that this may be difficult. This may be, in some ways, just ugly to hear about, to see, to investigate, but it is vital. It goes to the foundation and the core of what we believe as Americans. So I want to, again, thank you for your work, your service to the country. I can think of nothing more important facing the Congress right now. With that, I'll yield back, Mr. Chair.
Thank you. Ms. Ross.
Thank you, Mr. Chairman, and I want to just thank the chair and the vice chair again. And I want to point something out about this commission that dawned on me because of something I read over the weekend. You know, the American public is paying attention to what we're doing here in the Rules Committee and on the floor because we now have 3 people who, let's just be honest, were at the heart of this conspiracy, who are refusing to allow Congress to hold them accountable for their actions. But there are so many people who have testified before this commission, provided honest testimony, despite whatever political or financial or occupational backlash they might have. And I know it's not in our jurisdiction, but I'd love to have a list of those brave men and women who have put their country first, as your commission has. And so I want to thank you for that. It is unfortunate that we're having to be here now for the 3rd time to consider lawless actions on behalf of people at the heart of this matter who will not put country first and who are not taking the laws of this country seriously. And we know that the framers took great care to ensure that the laws of this nation would apply to everyone, regardless of political position. Why? As Mr. Raskin said, we didn't want to have a monarchy. But former Congressman and White House Chief of Staff Mark Meadows has shamefully refused to comply with a duly authorized subpoena issued by your committee, and he has done this without even claiming that some of the things he doesn't want to testify to are privileged, because we know they are not. And the bottom line is this: we're a nation of laws. We're not a nation of kings and vassals, as Mr. Raskin has said. Every citizen in this country has got to recognize that the law applies equally to them. It is our duty here to make sure that happens and do that on the House floor. And so for the sake of our democracy, I urge my colleagues to support the rule, the underlying resolution, and I yield back.
Thank you. Mr. Neguse. All right, Mr. Neguse.
Sorry, my apologies, Mr. Chairman. I just, again, would echo the sentiments of my colleagues on my side of the aisle. I certainly think that they have said it well, and express my gratitude to
Vice Chair Cheney and to Chairman Thompson for their collective leadership. This has clearly been a contentious process and one that has required, I think, poise and decisiveness, and ultimately, above all else, a commitment to getting to the truth about what happened on January 6th and exposing those facts to the American public. And so I want to say thank you to both of you. You have done a tremendous job, and I think the way in which you've worked with each other in ensuring that the committee's business is achieved is something for everyone in our country to follow and to emulate. So with that, I yield back.
Thank you. I just want to make a couple minutes of closing remarks, just for the record. I think it's notable that as of the start of the meeting, that there has been zero mentions on Fox News of their host text to Mark Meadows. The text that Ms. Cheney read last night at the Select Committee's meeting, not one. And that's despite the fact that one of the hosts that texted him was live on the air all morning. I can't account for what was said while we were in this hearing. But look, I'm glad that these hosts privately pushed to stop the violence on that awful day. But what I'm upset about is that is what they've publicly said ever since. That what happened that day somehow wasn't the fault of Donald Trump and his allies. That what happened really wasn't a big deal. That all this is being overhyped. This would be a good time for these hosts to use their platforms to tell the American people the truth, just like they were privately texting Mark Meadows the truth on that terrible day. That the president's inaction hurt us all, that he should have done more, that he should have pushed to stop the violence. But I have to say that their silence is deafening. And I just also want to remind my colleagues what one lawmaker texted to Mark Meadows after the January 6th attack, and let me quote, "Yesterday was a terrible day. We tried everything we could in our objection to the 6 states. I'm sorry that nothing worked," end quote. Now just think about that. A lawmaker is apologizing for failing to steal an election, for failing to overturn the will of the American people. I mean, is that really what our politics have become? You know, destroy democracy if your team isn't victorious. And I'm really worried that some of what we are hearing from the other side is just an attempt to run out the clock, to keep things in the dark so the truth stays buried. So we're here today to get to the truth, and that's what this is all about. And the final thing I'm going to say is I was here on that terrible day on September 11th, and I had my share of disagreements with the Bush-Cheney administration. But on that terrible day, in the aftermath of that horrific attack, Democrats and Republicans came together, stood on the steps of the Capitol, sang God Bless America, and to try to show the citizens of this country that we are one, and to show the world that we're united in our outrage against the terrible violence that we just experienced. And I thought after January 6th, what we all witnessed, what I witnessed, one of the last people off the House floor, I saw these people face to face. I thought when that was all over with, something similar would happen, that we would come together and all speak as one in our condemnation of what happened here, and all be committed to getting the truth. That didn't happen. You know, and the lack of curiosity, the lack of outrage, you know, the rationalizations why we shouldn't be compelling people to testify is just stunning to me. A number of people have said it, and I know you have as well, that, you know, we're at a crossroads. I mean, our democracy is being threatened, and this is serious. And as I said in the beginning, you know, coups very rarely succeed the first go around, but they oftentimes do the second time around. So this really, if there's ever a moment to kind of be above politics, it's now. And I get it. I mean, maybe if all the primaries were out of the way and we were having this discussion, maybe it would be a little bit more balanced. But but we have an obligation to get this right. And I want to commend the chair and the vice chair for their courage in doing this work. I think history will reflect well on what you were trying to do here, and we want you to succeed. So with that, no other people wanting to ask questions, you are free to go, and thank you so much.
Thank you.
I now want to welcome our next panel to testify, Representative Armstrong. I see him on the screen, but all right. Can you hear us?
I can.
Okay. The floor is yours.
Thank you, Mr. Chairman. 12 days ago, this committee held a hearing on a related contempt resolution against Jeffrey Clark. Since that hearing, the DC Circuit has issued its holding in Trump v. Thompson, which found that the former president's claims of executive privilege are not valid. My Democratic colleagues have proclaimed that this opinion justifies all of their actions and goals. It does not. The committee's repeated attempts to hold individuals in contempt of Congress is not timely and therefore unjustified, while the recipient of the subpoena is exercising his legal right to challenge the subpoena. As I stated in my December 2nd testimony, the application of executive privilege in this scenario is not our decision to make. Our decision is to determine whether this pending contempt referral is premature. By acknowledging the various court proceedings that will ultimately determine the validity of Mr. Meadows' objections, my Democratic colleagues implicitly confirm that these legal challenges to the committee's subpoenas are legitimate. Finding that the legal challenges are valid and knowing that the legal rights are not exhausted, it is illogical to hold in contempt the individual who asserts that legal challenge. President Trump has already announced that he will petition the Supreme Court to grant cert in Trump v. Thompson. In fact, in the ruling issued on December 9th, the court gave President Trump 14 days to file his appeal. We are holding a contempt hearing today, and the deadline for filing the appeal is not until December 23rd. Regardless of any opinion associated with the ruling, and I'm sure there are many, one thing is for certain: the DC Circuit is not last. Holding a contempt hearing because you really like the opinion does not toll the timelines created by that same ruling. President Trump's case is still pending. Mr. Meadows' case is still pending. The committee cannot have it both ways. You cannot cheer a substantive legal holding and declare it as dispositive while ignoring that the procedural rights of the litigants are not exhausted. Political timelines do not alter the continued legal right of Mr. Meadows to challenge the subpoena in the court system. Mr. Meadows has cooperated with the committee in good faith while maintaining a legitimate assertion of executive privilege. He has been responsive to the subpoena by providing nearly 7,000 pages of non-privileged emails and documents, along with over 2,000 text messages. He has offered to provide written answers to questions pertaining to executive privilege. He only withdrew his willingness to be deposed after learning that the committee sought his personal communications from Verizon. The committee's rejection of Mr. Meadows' privilege claims are not dispositive. Mr. Meadows, just like Mr. Clark, and just like any other individual, has a legal right to challenge a subpoena. The court system will determine whether Meadows' claims are justified. Until then, this contempt resolution is without merit. Further, as Mr. Meadows' attempt to accommodate the committee's subpoena while maintaining a good faith invocation of privilege does not meet the contempt statute's mens rea element that one will willfully default on responding to a congressional subpoena. Mr. Meadows is not willfully defaulting. Mr. Meadows has asserted the executive privilege claim and has exercised his legal rights to challenge the subpoena. He has complied with the information request pertaining to non-privileged information. We must also acknowledge that as White House Chief of Staff during the time at issue, Mr. Meadows could be party to every conversation involving the president. The conclusion must be that the contempt resolution against Mr. Meadows is still premature. It will continue to be until the Supreme Court disposes of Trump v. Thompson by denying cert or adjudicating the claim, and the claim of executive privilege, as well as others applied to Mr. Meadows' litigation. Mr. Meadows has sued to quash the subpoena, which was recently filed in district court. And again, while much has made and will continue to be made about executive privilege questions and the DC court's ruling, That is not the only issue being raised by Mr. Meadows. Mr. Meadows has the legal right to ask the court to weigh in on these issues. Recipients of subpoenas retain their constitutional rights and various privileges throughout the course of an investigation. That was decided in Trump v. Mazars, quoting, I think it was either Watkins or Quinn, I don't remember. On the basis of the Verizon subpoena alone, Mr. Meadows clearly has a reasonable argument that the committee overstepped. The subpoena was issued on November 22nd, while the parties were negotiating in good faith and without Mr. Meadows' knowledge. Instructed Verizon to produce information associated with Mr. Meadows' personal phone number. It included subscriber names and contact information, authorized users, times of service, account changes, IP addresses, and other metadata for 4 months dating from October 1st through January 31st, 2021. Trump v. Mazars held that to narrow the scope of a possible conflict between the branches, courts should insist on a subpoena no broader than reasonably necessary to support Congress's legislative objective. Requesting 4 months of all calls, text, and cell site analysis for anyone communicating with the president's chief of staff is a lot of things, but I don't think narrow in scope is one of them. Mr. Meadows has every right to contest this, and clearly the appropriate place to do so is in federal court. In fact, Congress itself has recognized that the courts are an appropriate place to resolve these disputes. During the Whitewater investigation, the Senate threatened judicial enforcement of a subpoena against President Clinton. So to conclude, Trump v. Thompson is still pending. The earliest that case can be resolved is December 23rd. Mr. Meadows has a valid suit that raises substantial legal questions that has been properly filed and will be properly heard. The committee seems unwilling to acknowledge the due process considerations of the court system affords, while simultaneously cheering on decisions from the very court system's ruling when it favors their political argument. And just finally, I would say this. You cannot in good faith assert just 12 days ago that Justice Clark should have went to court if he wasn't going to comply, and then today assert that Mr. Meadows cannot go to court if he doesn't comply. But that is exactly what's happening. No matter how much many of you want that to be different, the fact is this. The party issuing a subpoena is not the final determiner as to whether that subpoena is valid. And it doesn't matter if it's in Congress or a plaintiff in a divorce case in family court. And while that might screw up political timelines, it also ensures that the process is determined by a third party without any political skin in the game. And with that, I yield back.
Thank you. I have no questions. Mr. Cole.
I just want to thank the gentleman for his testimony, which is very consistent with what he delivered when he was here last week. I think he makes a really superb case, and I commend him for that. But I know we're on a tight timeline, Mr. Chairman, so I'll try to facilitate us getting to the floor as rapidly as we can. I know we all want to do that, so I will yield back.
That's why I love you. Mrs. Torres.
No questions.
Dr. Burgess.
I'm going to assist the ranking member in complying with the tight timeline. I yield back.
Anybody on our side want to say anything?
One thing.
Perlmutter?
I guess not.
Oh, no, you can. Yeah.
Just curious, Mr. Armstrong, Mr. Clark, in his most recent letter, said he's going to assert the Fifth Amendment. Any idea why Mr. Meadows hasn't suggested that?
I have no idea. I can't speculate.
I yield back.
Mr. Reschenthaler. Mr. Raskin.
Just 3 quick points in 60 seconds, and the gentleman can respond if he wants to. Number one, his entire argument was devoted to places where there might be some controversy around privilege, although I don't think that really exists, but fair enough. What about the 9,000 pages where any claim to privilege has clearly been waived and abrogated? Does the gentleman not think that the committee has the right to interview Mr. Meadows about all of these unprivileged documents that he voluntarily submitted to the committee? Number two, as opposed to the theory offered by the chair and the vice chair of the committee that Donald Trump's calling his book fake news was the precipitating factor of Mr. Meadows pulling the plug suddenly on his participation with the committee, you offer the suggestion that it was because he discovered suddenly, I think many weeks later, that his phone records were somehow at issue with the committee. But in fact, the committee's not going to get the substance of any communications. It's simply the records of calls having taken place. And I think the gentleman would agree that the Supreme Court has said that that is not material that's covered by Fifth Amendment privilege or Fourth Amendment, or that requires a subpoena. That's just an objective fact in the world, whether calls took place. And finally, I think the gentleman has offered misplaced emphasis on the Mazars case, which deals with a situation where there's a conflict between the branches. Here, the two branches agree. President Biden has said for the executive branch, there's no executive privilege that's being asserted, and Congress agrees that this material is absolutely necessary. And of course, as you know, the D.C. Circuit found that not only was there no compelling interest to override the people's right to get this information, but Donald Trump didn't even offer one. I yield back to you, Madam Chair. Or if you have any comments you'd like
I don't
to
think
make.
it would be. I don't think it'd be a hearing, Mr. Raskin, if you and I had a little back and forth, unless you and I had a little back and forth on something. One, on the negotiation thing, I would say this. Negotiations are either completed or they're not. And I've read all of the correspondence, and I would actually contend that Mr. Meadows has worked very diligently to provide non-privileged information and has at least expressed viable options for dealing with the privilege issue. But you cannot reasonably expect somebody to show up in an adversarial position when you have essentially told them that you will ask them about what is being contended to be privileged in the middle of the non-privileged information. That is an unrealistic place to be. It is an unrealistic place to be in an adversarial deposition. And either negotiations are complete or they're not. And you just say, we're going to ask you about unprivileged information, but then we're going to ask you about information, and you do it line by line in an 8-hour adversarial deposition. With regards to the Verizon case, whether it's Fifth or Fourth Amendment implications, and I think this is something that we should be careful of just wholly regarding whole investigation. This isn't a criminal case, and a criminal prosecution is not legitimate legislative purpose. And as we keep veering into those areas and mixing the grounds, listen, we are reading out of criminal statutes far too often in defense of this investigation. I have to remember that is specifically determined that a case is not a legislative purpose. And with regards to the privilege claim and conflicts between the two branches, Nick, we've talked about this before, and I'll be brief here, has asserted that former presidents have some right to executive privilege, and it's a totality of the circumstances. That's where, regardless of how this is going to be determined, the times aren't done in court. They just simply aren't. These cases are not finished yet. And so with that, I yield back.
Okay. I'll just say before yielding back to you, Madam Chair, as Mr. Morelli emphasized, if you agree that a certain category of subject is not privileged and you offer documents about it, that does not absolve you of your obligation to testify about it. People are called to produce documents, papers all the time and then testify about them, and a witness doesn't get to choose between them. I yield back to you.
Ms. Fischbach.
Thank you, Madam Chair. And Mr. Armstrong, you kind of, I think you were just getting into it, but just to be clear, criminal contempt is not subpoena enforcement, is it?
No.
And if the goal is to enforce the subpoena, what action would the majority, would the committee take to compel the information they seek?
Well, you can go to court. I would not pretend what they would think, but you can go to court to compel the information. But I will say this, once you go down the road of criminal contempt, the likelihood of obtaining any testimony at all is significant.
Well, and Mr. Armstrong, the question remains, as with the other resolutions that we dealt with, what legislative purpose or otherwise are they trying to reach with the subpoenas? And so would this resolution have in regard to the stated goals of the select committee?
Yeah, the legislative purpose question is, and that's what I was talking about, going back and forth and inferring criminal conduct, utilizing criminal statutes. That is not a clear, legitimate legislative purpose. It just simply isn't. It may be a great political purpose, but so I think, listen, I just think we should be a little careful about that in general.
Thank you, Mr. Armstrong, and I yield back, Madam Chair.
Ms. Scanlon.
Thank you, Madam Chair. There've just been a couple references suggesting that somehow it's too rushed to seek contempt at this point, or that there have been insufficient efforts to accommodate Mr. Meadows. I would just refer anyone who's interested in what's actually transpired to the Select Committee's report that was filed with the House yesterday, and pages 12 through 19 detail in excruciating detail the issuance of the subpoena 3 months ago, and all of the back and forth and back and forth. It has not been a couple of letters. It has been intensive, and I think the Select Committee has gone well above and beyond any reasonable accommodation, and this just can't be dragged out forever. So with that, I yield back.
Mr. Morelli. Mr. Morelli. Mr. Saunier. Ms. Ross. Mr. Neguse. Does any other member of the committee wish to ask a question? Seeing none, I would like to thank our witness for their testimony. Please leave with our stenographer or submit electronically anything that you would like inserted into the record. You are now excused.
Are there any other members who wish to testify on this resolution? Seeing none, this closes the hearing on the resolution. At this time, the chair will entertain a motion from the distinguished gentleman from Maryland, Mr. Raskin.
Mr. Chairman, I move the committee provide for consideration of the resolution accompanying House Report 117-216 under a closed rule. The rule provides that if House Report 117-216 is called up by direction of the Select Committee to investigate the January 6th attack on the United States Capitol, all points of order against the report shall be waived and it shall be considered as read. The rule provides 1 hour of debate equally divided among and controlled by Representative Thompson of Mississippi, Representative Cheney of Wyoming, and an opponent or their respective designees. The rule waives all points of order against consideration of the resolution accompanying the report. Finally, the rule provides that the resolution accompanying the report shall be considered as read.
You heard the motion from the gentleman from Maryland. Is there any amendment or discussion? Hearing none, the vote now is on the motion from the gentleman. All those in favor say aye. Aye. Opposed, no. Opinion of the chair, the ayes have it. A recorded vote has been requested. Clerk will call the roll.
Mrs. Torres. Aye. Mrs. Torres. Aye. Mr. Perlmutter.
Aye.
Mr. Perlmutter. Aye. Mr. Raskin.
Aye.
Mr. Raskin. Aye. Ms. Scanlon. Aye. Ms. Scanlon. Aye. Mr. Morelli.
Aye.
Mr. Morelli. Aye. Mr. DeSaulnier.
Aye.
Mr. DeSaulnier. Aye. Ms. Ross.
Aye.
Ms. Ross. Aye. Mr. Neguse. Mr. Cole.
No.
Mr. Cole. No. Mr. Burgess. No. Mr. Burgess. No. Mr. Reschendahler. Mr. Reschendahler. No. Mrs. Fishbach. No. Mrs. Fishbach. No. Mr. Chairman.
Aye.
Mr. Chairman. Aye.
Clerk report the total.
8 yeas, 4 nays.
The motion is agreed to. At this time, the chair will entertain a motion from the distinguished gentlewoman from California, Mrs. Torres.
Mr. Chairman, I move the committee grant H.R. 5665, the Combating International Islamophobia Act, a closed rule. The rule provides 1 hour of debate equally divided and controlled by the chair and ranking minority member of the Committee on Foreign Affairs or their designees. The rule waives all points of order against consideration of the bill. The rule provides that an amendment in the nature of a substitute consisting of the text of Rules Committee Print 117-23, modified by the amendment printed in the Rules Committee report, shall be considered as adopted, and the bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended, and finally, the rule provides one motion to recommit.
You heard the motion from the gentlewoman from California. Is there any amendment or discussion? Hearing none, the vote is on the motion from the gentlewoman from California. All those in favor say aye. Aye. All those opposed say no. Opinion of the chair, the ayes have it. Yeas and nays have been requested. Clerk will call the roll.
Mrs. Torres. Aye. Mrs. Torres. Aye. Mr. Perlmutter.
Aye.
Mr. Perlmutter. Aye. Mr. Raskin.
Aye.
Mr. Raskin. Aye. Ms. Scanlon. Ms. Scanlon. Aye. Mr. Morelli. Aye. Mr. Morelli. Aye. Mr. DeSaulnier.
Aye.
Mr. DeSaulnier. Aye. Ms. Ross. Aye. Ms. Ross? Aye. Mr. Neguse? Mr. Cole? Mr. Cole? No. Mr. Burgess? No. Mr. Burgess? No. Mr. Reschendahler? No. Mr. Reschendahler? No. Mrs. Fishbach? No. Mrs. Fishbach? No. Mr. Chairman?
Aye.
Mr. Chairman? Aye.
Clerk, report the total.
8 yeas, 4 nays.
The ayes have it, the motion is agreed to, I will carry this for the majority. Mr. Raskin will carry the contempt resolution for the majority. Yeah, and on your side.
Ms. Fishbach will carry the contempt resolution. Mr. Reschenthaler will carry the matter we just held.
Okay, and the contempt resolution will be up at 12:15, I'm told. 12 sharp. I'm sorry, 12 sharp.
12:15, you guys show up at 12:15.
I just,
Yeah, they're gonna be first.
just want to note for the record, we facilitated
You
this
did,
last
and I appreciate it. Yeah, so we're still waiting to figure out on the debt ceiling when the Senate's going to be done, but.
Good luck with that.
Yeah, so it could be today, but if it is late into the night, I would prefer that we meet in the morning and do it tomorrow, but we will keep you apprised of what's going on over the Senate. All right, with that, all right, with that, the committee stands adjourned.